Hello, everybody, and welcome to today's webinar. First of all, allow me to introduce myself. My name is Sam Keshavarzi. I'm one of the adjudication managers here at TDS. Today, I'll be with Louise Breeze, also another adjudication manager at TDS. So, a wealth of experience between the two of us. But just before we get cracking, what I will do is just do a few of housekeeping things. It was on the previous slide, but for those of you who have just joined us, if anyone at any point does have any connectivity problems or issues or just lose connection, you can simply just refresh your page. If that doesn't work, just please re-click the link that you've got. It should just allow you to rejoin the session. Hopefully you won't have missed too much. But what I will do is I'll just leave this slide on. So in the worst case scenario, something's gone completely wrong, those are our two email addresses there. So please just drop us an email. The good thing about there being two of us today is whilst the other one's talking, the other one can quickly monitor their email. So please don't hesitate to contact us if you do. Also today, please ask as many questions as you want. We will have some ample time at the end for Q&A. So just as you go, please answer those questions. What we'll do is we'll just collate them and go through them at the end. So we'll allow them to build up and then hopefully go through them. But it should just be on the left-hand side. There should be a little questions icon for you. Which you can then just pop any questions you've got in there as well. But that's all from me from the housekeeping perspective. As I said, so my name's Sam, and I'm here with Louise. Between the two of us, so I come from an ADR, an ombudsman background. Louise comes from a background in the private rented sector. So between the two of us, hopefully we'll be able to go over anything that you may or may not know. And as I say, if you've got any questions at the end, please throw them at us, and we'll see how far we can be challenged in answering those. But did you have anything to add there, Louise, or you're happy to crack on?
Yeah, no, happy to crack on. Hello, everyone. Yeah, as Sam mentioned, my name's Louise, also an adjudication manager. I've worked for TDS for 9 years now, so quite a long time. So hopefully we'll be able to answer any questions that you have at the end.
Amazing. So just to start off, just a bit of background on who we are, what we do. So TDS, so we are obviously we're a tenancy deposit scheme. So we are actually the UK's longest running government approved tenancy deposit scheme. And essentially what we do is we protect deposits in two of our schemes. So we have the insured scheme and we have the custodial scheme as well. So the difference between the two of those is simply just who holds on to the deposit. So the insured scheme is essentially where an agent or the landlord, they're the ones who hold the deposit. Custodial scheme is where we would then hold the deposit when it's protected. But in terms of a lot of the things we'll be going over today, the principles, the concepts, it doesn't matter what scheme, essentially, the deposits they're protected. But just in case you wanted to know the difference between the two, those are the different ways that deposits can be protected. We also provide, and we also try to resolve any disputes at the end of the tenancy. So if for the duration of a tenancy something's gone wrong, our dispute resolution service, which is the team that me and Louise work with the adjudication team, we offer a free service that essentially allows us to be impartial and tries to resolve any dispute. So if there's something that's not just gone right, an allocation of that deposit at the end, it would be up to essentially the deposit scheme to try and provide some impartial service to get that resolved and to get all parties moving on and essentially being able to draw a line under it. We also offer support as well. So it's not just, we don't just get involved at the end of the tenancy if something's gone wrong. We also offer support during the tenancy as well. So we do offer, as an example, and we'll touch on this in a few of the later slides in a bit more detail, but we also offer mid-tenancy mediation services as well. So rather than allow for something to go wrong and it gets to the end of the tenancy, what we'll try and do is we'll try and help to maintain that relationship during the duration of that tenancy, and just rather than let it get to a point where no one wants to proceed any further, really just try to get everyone talking. So we do also offer that service as well. So in a very, very quick nutshell there, that's the sort of different services that we offer, and the different ways that we get involved with tenants such as yourselves, landlords, agents, and sort of the role that we play in that overall private rented sector.
Lovely, thanks, Sam. So just to discuss deposit protection in a bit more detail. So what is deposit protection, essentially? What is it that we're doing here? So deposit protection is a legal requirement that ensures your tenancy deposit is safeguarded in an approved scheme. And in England and Wales, landlords and agents must protect your deposit within 30 days of receiving it. And they must also provide details of the scheme in which it's protected. This is a legal requirement. So what that means is it's something they have to do. So they have to protect your tenancy deposit, and they have to also provide you with details of that scheme. Now, that 30-day time limit, that's an absolute time limit, and the clock starts ticking on the date that the landlord or agent receives your deposit. So the day that you hand that money to them, that's when the 30-day timeline starts ticking, and they must make sure that they've protected it with TDS or another deposit protection scheme within those 30 days. Now, why does this matter? Deposit protection means your money is held securely, and you also have access to an impartial process to decide any disputes about deductions when you move out at the end of the tenancy. So essentially what we're doing is we're protecting the deposit. We're making sure that those deposit monies are kept safe. We're either holding those deposit monies in our custodial scheme, or we're insuring those deposit monies. So if anything happens to those during or at the end of the tenancy, we insure and protect that money so that it doesn't go missing. It also helps to make sure you get your deposit back quickly. We have government regulated timescales that we have to meet. But this is on the proviso, of course, that you meet your obligations and that any proposed deductions are considered fairly by an adjudicator at the end of the tenancy. So if there is a dispute at the end of the tenancy where perhaps the landlord wants to make a claim against the deposit, but perhaps you don't agree for certain reasons, then an adjudicator will make that fair and impartial decision. Now, this on the slide here is just an excerpt of the prescribed information. Now, this is the prescribed information that we have available on our website. It's longer than this, actually. It's a few pages long, but couldn't really fit it on the slide here. But just to give you an example of the information that you're supposed to be provided with within 30 days of paying your deposit monies. So this sets out the deposit protection scheme that it's been protected in, and other information there, contact details, so that you can ensure that you can get your deposit back at the end of the tenancy. So this is what you should be looking out for as having been provided to you by the landlord or the agent. Now, what happens if a landlord or agent doesn't register and protect your deposit within 30 days, or they don't serve your prescribed information within 30 days? Now, there are some statutory penalties for failing to do that. Remember, it's the law, they have to do it. So if they breach that requirement, then there are penalties. So if they fail to protect the deposit, then the tenant can take the landlord or the agent to court. The court can then order the landlord or agent to either protect the deposit immediately or to repay it in full to the tenant. Now, on top of that, the court can also order the landlord or agent to pay the tenant compensation of between 1 and 3 times the deposit's value. Now, you can imagine that can amount to quite a large sum of money when we think about how much deposits are. And also, a landlord or agent is not able to regain possession of the property via a Section 21 notice until the deposit's been repaid or after any court case about the deposit has ended. So there are some quite severe penalties there for failing to protect the deposit within 30 days. Similarly, for failing to serve the prescribed information within 30 days, now that's the information we saw on the previous slide, possession of the property can't be regained until that prescribed information has been given. If it takes place after 30 days has passed, then the landlord or agent, then the tenant can still apply to court. So a landlord or agent can actually serve the prescribed information late, then attempt to regain possession of the property. However, the breach has already happened. They've already made the mistake and they've already made that error, which means that the tenant can still go to court and they can again or apply for the court to order the landlord or agent to either protect the deposit or repay it in full. And then again, the court can also order the landlord or agent to pay the tenant compensation of between 1 and 3 times the deposit's value. So both breaches have quite serious consequences. Now, just to mention here that TDS, we don't actually regulate this legislation. We do sometimes have cases where a tenant might say that their deposit's been protected late. However, they'd have to pursue that via other means and obtain some legal advice, perhaps from the Citizens Advice Bureau or another place there. So perhaps a solicitor if they want to go down that route of taking the landlord to court. So what are counterclaims? So a counterclaim is essentially a legal claim that you can raise in response to a landlord's claim against you. So you're turning the tables by making your own claim in the same dispute or court case. So you might consider a counterclaim if your landlord takes action against you. So perhaps they're suing you for unpaid rent. And then the counterclaim would address issues where the landlord may have breached their obligations to you. So, for example, a landlord is claiming that you, the tenant, owe rent arrears. You could then counterclaim for issues caused by the landlord. And so, for instance, serious disrepair that the landlord ignores, and those sorts of claims, they can offset what you owe as rent arrears, or even result in the landlord owing you money. Now, it's crucial to understand that TDS does not consider tenant counterclaims. And the reason for this is the deposit is specifically taken as security against any breach of the tenant's obligations contained within the tenancy agreement. So if your dispute is passed to an adjudicator at the end of the tenancy, they will only be looking at the tenant's obligations. Has the tenant met their obligation to pay rent? They won't be able to consider any counterclaims or any reasons as to why that rent hasn't been paid. So it might be where you have a very valid counterclaim and actually court might be a better option for you there. A court can certainly consider your counterclaims and take those into account when determining how much, for example, in this example, rent is owed. So rent arrears, understanding obligations and consequences. So rent arrears, that simply means you're behind on rent. So it says here on the slide, even just 1 month late is an arrear, but even just 1 day late is an arrear. If you've missed the date on which your rent is due, then you are in arrears. And multiple months can add up very quickly. So it's really important to keep track of payments to avoid falling into arrears inadvertently. Now, if you fall into serious arrears, your landlord can take legal action against you. They can seek to evict you for non-payment of rent, and they can do this by serving a formal notice. It's called a Section 8 notice, and going to court. And in England, as it currently stands, owing 2 or more months' rent can be grounds for an eviction notice. Now, I would note here that we do have the Renters' Rights Bill, which is currently going through Parliament at the moment, and that position might slightly change as to when it's considered sufficient rent arrears for a landlord to evict a tenant. However, as it currently stands, owing 2 or more months' rent are grounds. So as a tenant, you are required to pay your rent in full and on time according to your tenancy agreement. So make sure you read and understand your tenancy agreement. If you miss payments, those unpaid amounts become rent arrears, which is debt you owe to your landlord. And it's really important to understand as well that a landlord might actually be entitled to claim interest on top of that late payment of rent. However, this is capped, and there are certain deadlines before that interest can become payable. So the rent should be late by 14 days. That's when the interest will kick in, and it cannot exceed 3% above the Bank of England base rate. So legal action and credit impact. So besides eviction proceedings, sort of losing your home, landlords can actually claim for the unpaid rent as well. They can do this via adjudication against the deposit or by court order. So if the court issues a judgment against you for rent arrears, it will appear on your record. So a CCJ, a county court judgment in England and Wales, and this can harm your credit score and make it harder to rent another home. Future landlords do often check references or credit history, so it's really crucial, really, that you don't have a CCJ against your name, because that is likely to come up in any credit history reference checks. So it's crucial to act early. Communicate with your landlord if you know that you'll be late on rent. They might agree to a payment plan or a temporary arrangement. You can also seek advice from a housing charity or tenant advice service. And addressing money problems promptly can often prevent the situation from escalating to eviction or court. So navigating disputes and defending claims. So stay calm and communicate. If a dispute with your landlord arises, it might be about rent repairs or something else, try to resolve it informally and politely discuss the issue or write to your landlord. And many problems can be solved with clear, calm communication and understanding. Document everything. Keep written records of all interactions. Save your emails, letters and texts. Take photos of any relevant property conditions, dated before and after photos for cleanliness or damage. Also keep receipts or bank statements showing rent payments. Good documentation is your best defence if disagreements persist or worsen. And it's certainly important information and crucial evidence in the event that a dispute arises. Know your rights and options. So understand the formal processes that are available to you. If talking doesn't work, you might want to use a free dispute resolution or mediation service. So as Sam alluded to, we not only have an adjudication service at the end of the tenancy, but we also have a mediation service for sustaining tenancies during a tenancy for any disputes that arise. So defending a claim, what do you do if a landlord makes a claim against you? So if a landlord does decide to take legal action against you, so perhaps filing a court claim for rent arrears or property damage or through adjudication at TDS, don't ignore it. Respond promptly. You will have deadlines set out in which you have to respond. So make sure you meet those deadlines and read the information very carefully, and be prepared to tell your side of the story. So you have a right to defend against the claim. You can dispute the claim and defend it. You can defend it in part. Perhaps you might agree to some claims and not others. Or if you agree to it, then you can absolutely agree to that claim as well. There's no actual dispute there. So this means you can submit a defence and evidence to the court or for adjudication as well. But you should only defend if you are confident in your defence, and legal advice should be sought. So seek support if needed. You don't have to handle disputes alone. If you feel unsure, get advice. Contact a tenant advice organisation, legal aid clinic or Citizens Advice Bureau. They can help you to understand the process. They can draft responses for you, or even represent you in mediation or court. And having guidance can make it less stressful to navigate disputes and ensure you present the strongest case possible. So protection from deposit deduction. How can you protect yourself from the landlord claiming against your deposit? So at the top here, I've written, check your tenancy agreement. What have you actually agreed to in your tenancy agreement? you'd be surprised how many tenants we speak to who don't read their tenancy agreements clearly and understand every obligation that's being placed on them. But once you sign that tenancy agreement and you move into that property, you're agreeing to be bound by those obligations. So check your tenancy agreement. Have you met all those obligations contained within it? Pay your rent on time. If you pay your rent on time and in full, then that's fine. But if not, unpaid rent can be deducted from your deposit. Now, remember, we don't deal with counterclaims at the tenancy deposit scheme. So if you feel that there's a valid reason why you haven't paid your rent, it may be that the adjudicator will still be able to award that rent from the deposit monies. Keep the property clean, report any damages or maintenance issues promptly. If you do see any maintenance issues in the property, make sure you report those. There's usually a contractual obligation to do so, so make sure you meet that. Try to fix any minor issues that you might have caused or inform the landlord so it can be addressed. And then when you're moving out, strive to leave the property in the same condition and standard of cleanliness as you found it, subject, of course, to fair wear and tear. Repair any damage you're responsible for if possible. Ensure you don't leave any belongings behind. All those sorts of things can result in claims. Also attend the checkout inspection if there is one. That does help to avoid disputes. It shows that you've done your part, you're there, and you can understand if there are any issues that have been found at checkout.
Thank you, Louise. And just to, I know we've touched on it quite a couple of times now about the tenancy redress service, but just to touch on it again, I think the next few slides after this will basically just show us the sort of things that you might be able to might be able to come to us about if you are interested, or if it's something that may help. I think Louise has mentioned a couple of points on this slide, but just to reiterate it again. So essentially, the redress service, it is designed for tenants who essentially have a complaint perhaps with their landlord during that tenancy. So it really is there just to facilitate that mediation in cases where both parties, they are committed to sustaining that tenancy, but there's just they just need maybe some other third party or just someone else to get involved to essentially help both parties get to where they need to get. So if the sort of things that the redress service then can look into, it is a whole variety of different areas. So just a few examples here. So rent arrears, if the property isn't to the correct standard, or if something's broken in the property, or something's not working, or a common example, I've sat in on a couple of these mediations before, and there's circumstances sometimes where a landlord, it's coming into the property unreasonably, or wants to check in every couple of weeks, and the tenant on the other side of it, that they have that right to enjoyment in the property, and that they don't want the landlord to come in. So a whole different variety of examples here of the different sort of things that the redress service can essentially help mediate. And the way that it essentially works is just by putting the parties in a virtual room. So we'll have a conversation with the tenant yourselves, we'll have a separate conversation with the landlord, and what we'll do is, if at that point hear both sides of the argument, if everyone's happy to be then brought into the same virtual room, that's when that discussion happens between everyone in one place. So those are the sorts of things that perhaps we would be able to look into. But it doesn't mean then it's all only good saying there's a lot of things. It doesn't mean that we can look into everything. So the tenancy redress service, it wouldn't be able to look into the specifics of evictions, for an example. If there has been criminal activity or some serious antisocial activity, for example, it's not something we would then be able to get involved in. In regards to actual tenancy deposit issues, because it's a mediation for when the tenancy is actually still ongoing, and it's essentially there to try and maintain that relationship. If it is a problem regarding the actual deposit at the end of the tenancy, it's not someone that would be able to go through this avenue. And also legal advice as well. It's not something that where legal advice could be given or sought out. There would have to be other bodies where you'd have to go to do so. But if that does sound like something that might be of use for you, or something that you might find interesting, or even just something to know that it might not necessarily be something that you need now, but you never know, maybe maybe in due course or in the future, or another tenancy might be useful. That's just our email address or where to get some further information. So I'll just leave that there for a couple of seconds if anyone does want to quickly jot that down. So we've mentioned there, what if there's something perhaps gone wrong during a tenancy, but what if something does go wrong at the end? And I've referenced it a couple of times today. ADR, the word adjudication. So what does that actually mean, and what does that actually entail? So very, very simply, an adjudication is essentially an alternative way of resolving a dispute that's not the traditional way of going to court. So it's essentially there to offer it as a free service to the parties. That, as I said, if you don't want to go to the court, you don't want to go through that perhaps more long-winded avenue, it is another way of resolving that dispute. So essentially the way it works is it's very much document-based, very much evidence-based, and an impartial adjudicator will assess those documents, they'll assess that evidence, and they'll come to what they consider a fair and impartial outcome. So the adjudicator will consider all the evidence they've been provided, and then they'll decide how to allocate that deposit if it's not essentially been agreed on. So that disputed amount, so if, for example, just to throw some figures out there, if the deposit was £1,000 and only £500 of it is in dispute, that's what the adjudicator will be considering. They'll be considering that £500 of disputed deposit, and then they'll be considering the facts, and then they'll essentially consider how that money should be allocated out. To proceed with ADR, to proceed with a new adjudication, we do need the consent of all parties. And the reason for that being is once that consent is provided, essentially that decision does become binding and it is final. So we would need that consent up front. Once that consent has been provided, it's essentially all parties saying, look, we're leaving it to the adjudicator here. They're impartial. They're going to assess the facts. Obviously, it's up to me as a tenant to provide the evidence from my side, the landlord, the agent to provide the evidence from their side. But we agree that once that's done, that the adjudicator's decision is final and binding. So just some sort of figures here, and the sort of different types of disputes that might come our way and might come to an ADR. And for your mathematicians out there, I know that these figures, they don't all add up to 100%, but that is because a lot of the time it's not just one simple issue. It could be, for example, just to have a look at some of these ones here, it could be something that, yes, it's rent arrears, and then the crux of the disputed amount is rent arrears, but there's also some damage that that a landlord or tenant want to be considered or want to be adjudicated on. So just some sort of context here and background to the sorts of cases that we do get come our way. As you can see, about just half of the cases that we do receive will have some element of cleaning, and rent arrears, it does form the smallest or the majority of our cases, where it is around 13%. But as I said, this is it could be a combination of all of them. It could just simply be a rent arrears claim. It could just be a damage claim, and obviously the figures and everything like that would be completely dependent on what is actually in dispute between the two parties. And just another one there on the right hand side of who actually raises the disputes, and we actually find nearly just over three quarters of all our disputes are actually raised by the tenants themselves. So that's basically, the landlord is trying to claim X amount of money, and I simply don't agree with that. For this reason, this reason, this reason. So 76% of our disputes are actually raised by tenants. So just once again, if you were interested in those sort of facts and figures, it's just there for you. And the role of adjudicators. So what is the role of the impartial person or body that's actually making those decisions? So an adjudicator, really, their role and their job is just to try and reach a fair and proportionate decision as much as they can, and do so in a way that's essentially clear for all parties to actually understand why they've come to that conclusion. So it's not going to an adjudication decision or publication. It's never going to be sort of heaps and heaps of legal jargon and trying to confuse parties and X, Y, Z. It's really just going to be setting out exactly what their reasoning is, what the evidence that they've been provided says, and the reasons why they're coming to a decision. So they're essentially trying to do it to make sure that everyone can understand the outcome, and no one's left it will always be the case where maybe someone isn't happy with how that's gone, but at least they understand the reasoning to why and how it's ended up to go either one way or the other. They'll always try and maintain fairness, integrity, and be as impartial as possible. So they're never, an adjudicator doesn't work for either side in the sense of, they're acting on behalf of the tenant or they're acting on behalf of the landlord. They are simply there just to try and maintain that fairness and integrity and make sure that decision is completely impartial and just based on the facts that are provided to them, which is why essentially that evidence information that you provide is so vital, because that's what they're going to be using and considering when they come to a decision. We'll always try and ensure that there's no conflict of interest. So that could be, it's very rare that there would be a conflict of interest, but in this maybe circumstance where perhaps, maybe there is in a certain area that the house is or the property is being disputed on, might be someone that they used to live down the road to that person, or it might simply be that they used to work in an area where they dealt with the agent or the landlord. So there could be potential conflicts of interest, but all of those ones would be eradicated before an adjudicator once again would ever get to that stage of issuing that decision. So we'll always be ensuring that there's no conflict of interest, and simply it is just the adjudicator assessing the facts of the dispute. All decisions and evidence remain confidential as well, so it's not anything that would be sort of shared beyond what needs to be shared on to come to the outcome of the decision. And all decisions have to be issued within the required timescale. So adjudicators, they work to a KPI, they work to a deadline that's essentially been set out by government. And so once that evidence and once that dispute has sits on an adjudicator's desk, they're required to issue that very swiftly and to all parties. So it hopefully will never be a scenario where a dispute is ongoing. It will, once it gets to an adjudicator, that they are required to issue that decision as soon as possible. And all of our adjudicators are actually an associate members of the Chartered Institution of Arbitrators, if I get my words out correctly. So all the adjudicators there, they are associate members of the CIRB, and what that is that's an accreditation that is separate to TDS, separate to the Tenancy Deposit Scheme, that essentially shows that they're doing everything I've said there. So that they can assess the evidence, they can do it in an impartial and fair way, and to be able to evidence that and show that is why they then get that accreditation of associate members. So all of our adjudicators are at TDS associate members. So is a dispute within our remit? So once again, it's all well and good us saying what, the sort of things we can look at, what adjudicators do, the sort of disputes that, we would consider, but does that mean that every dispute is within our remit? Sadly, it doesn't. So there are certain things that we can look into, there are certain things that we can't look into. So on the very well set out there, but on the right hand side there with the tick is essentially all the sort of things that we can look into. So some of these heads of claims here that are mentioned, and obviously those ones that we saw on the previous slide where it's broken down, where it was 13% rent arrears, 50% cleaning, for example, but they're just the sorts of things that we can look into, essentially those sorts of disputes. But the ones on the left-hand side are scenarios and circumstances where the dispute simply just wouldn't fall into our remit. So it's not something that we would then be able to consider. And we've mentioned counterclaims. So if a counterclaim is forwarded into us, it's not something that we would then be able to adjudicate on or trying to resolve that dispute. Just a few examples of these is, if it's not in a short hold tenancy in England, we can't look at it. It does have to be in a short hold tenancy. So that's the sort of thing, you'd see in perhaps a tenancy agreement. If it's a sort of short hold tenancy or an AST, we'd be able to look into it. If the deposit isn't protected with TDS, we then can't look into it. So there are, as we've mentioned, there's 3 deposit schemes, and we are one of those deposit schemes. Hopefully from our perspective, it would be protected with us, but if it isn't, we then couldn't consider that dispute. You would then have to go to the relevant deposit scheme that deposit is protected with for this service, and obviously to go through that adjudication. We can't, if the tenancy or is if it's If the deposit is protected within our insured scheme, we can only consider if it is within the tenancy's ended within that 3 months. So if it's been over 3 months since that tenancy is ended, we then wouldn't be able to consider it. That dispute then wouldn't fall into that remit based on the timeframes. If the dispute's between the landlord and agent, for example, once again, something we can't look into, or the disputes between tenants, or if very just simply it's just not about the deposit, it's something completely different, maybe someone's behavior or something else that's just not related to the actual deposit. And once again, we wouldn't be able to look into that. Sorry, I just went on to skipped a couple of slides ahead there just to make sure we never missed one. So best practice. Sorry, Louise, you're just on mute there.
Thanks, Sam. Apologies for that. So best practice in the private rented sector. So these are the sort of documents and information that we would recommend a landlord or agent collect. It's not the law. They don't have to do these things if they don't want to, but it's highly recommended that they do that. And you as a tenant as well should be aware of these sorts of documents so that you're best positioned to ask for copies of them and ask to see these sorts of documents. So starting at the top, and we've got a decent tenancy agreement, and that's a key document really because it sets out the obligations placed on a landlord and on a tenant. And if there's no written tenancy agreement, then it's going to be very difficult for an independent adjudicator to determine what's been agreed between the parties. You can, of course, create a tenancy verbally, but what's been agreed between the parties won't be clear to an independent adjudicator. So a decent tenancy agreement is a key document to ensure that you have really for your own security, and you understand what you have to do and what you can't do in that tenancy. A comprehensive inventory report with photographs. This should be created at the start of the tenancy and provided to a tenant for comment. The spirit of this document really is that both parties agree that this is an accurate benchmark showing the condition and the cleanliness of the property when the tenancy starts. And if both parties agree that that's how the property was when the tenancy started, then that can be used as evidence in the event of a dispute at the end of the tenancy. So, for example, a landlord might say, well, it's dirty at the end of the tenancy, I'd like it cleaned. But that inventory report might show, well, actually, it was dirty at the start of the tenancy. So it's very best practice, certainly, to have that document created. And as a tenant, it's a good idea to ask to see that site of that document so that you can make comments on it. You should also keep any written records of any agreements during the tenancy. It might be that there's been agreement with the landlord to make an alteration to the property. Perhaps it's been agreed that you can redecorate the bedroom, or it's been agreed that part of your rent doesn't need to be paid that month for some sort of reason. Make sure you have that down in writing and you've got that written record there, because if there is a dispute at the end of the tenancy, then certainly an adjudicator will need to see that objective written evidence to show what's actually been agreed there. So if you have a conversation with the landlord on the telephone, follow that up in writing just to clarify and make sure that everybody understands, what's been agreed there and, why perhaps your rent has only been part paid that month. So at the end of the tenancy, it's certainly best practice for the landlord or agent to carry out a checkout report. As I mentioned earlier, try and attend that meeting if you can. It will be helpful, I think, for you to sort of understand the types of issues that have arisen in that report, if any at all. And it's certainly something that you would need to see sight of at the end of the tenancy. And that document can be used to compare with the inventory report that was created at the start of the tenancy. So you can very clearly see that at the start of the tenancy, that the property was in that condition and cleanliness, and at the end of the tenancy, it was in that condition and cleanliness. And you should be able to see for each item throughout the whole property if there has been any deterioration beyond fair wear and tear, and if that claim against your deposit is justified. It's certainly best practice for a landlord or agent to keep rent statements and keep records of all payments that are made by tenants. But it's certainly also a good idea for a tenant to keep records of their rental payments as well. So keep your bank statements, etc., showing that your rent payments have been made. Errors do sometimes occur. Rent payments are sent, and perhaps not recorded on agents' rent statements. So make sure that you do keep records of any payments that you have made to the agent or landlord. So just talking about tenancy agreements in a bit more detail. So do remember to read your tenancy agreement carefully. Make sure that you do understand the obligations that have been placed on you and the landlord. They will set out, what the landlord has to do, what the tenant has to do, and what will happen if they don't do that. So it's really important to understand not only your obligations that have been placed on you, but your liability in the event that you fail to meet that obligation. The tenancy agreement should also contain a well-drafted deposit use clause. And a deposit use clause is a clause that sets out the permitted purposes for the deposit. So I've got an example on a later slide, but it will explain that the deposit can be used for usually cleaning, damage, rent arrears, and there's usually a mop-up clause which says, and any other breach of the terms of this tenancy agreement. And what that means is that if the evidence shows that any of those tenancy agreement clauses haven't been met, then the deposit can be used to remedy that breach. So perhaps there's an obligation to not cause any damage in the property. If the check-in and check-out report comparison shows there has been damage in the property, then that means that the deposit can be used to remedy that damage. You should also consider any specially negotiated clauses. So sometimes we see agents add in specially negotiated clauses. Perhaps it's relevant to that particular tenancy. Perhaps there's a pond that needs to be looked after, or you want to keep a pet in the property. So read those clauses carefully. Are they fair and reasonable? Can you reasonably meet those obligations that you're being asked to? So just remember to read your tenancy agreement carefully. Make sure you can meet all those obligations that's contained within it. So we've got some example clauses here. I appreciate they're quite wordy on the screen there. But starting with the top clause here, this says that the tenant shall pay to the agent the sum of £900 by cleared funds before the start of the tenancy. And thereafter, the tenant shall pay to the agent the sum of £900 per calendar month in advance by standing order on the 12th day of each month for every month of the tenancy, the first of such payments being due on the 12th of January. So this is a very clear obligation to pay rent. The tenant in this case will have to pay £900 to the agent in advance before the tenancy starts, and that's for their first monthly period. And then after that, they promise to pay on the 12th day of each month, £900, again in advance. So what that means is it's the start of the month of the tenancy. So on the first day of the tenancy, that first £900 must have been in cleared funds. And then for the first day of every following month after that, they must pay £900. And they're agreeing to pay that for the whole term of the tenancy. Now, the next clause down we have is the agent, with the consent of the landlord and the tenant, may deduct monies from the deposit to compensate the landlord or agent for losses caused for the following reasons. Now, this is your deposit use clause. Now, you should have this in your tenancy agreement, very clearly set out. If you don't have a deposit use clause, then it might be that the landlord or agent doesn't have a sufficient clause to actually claim against your deposit. You can see it sets out all the issues or clauses that claims can be made against the deposit. So for damage, we've got that mop-up clause there arising from any breach of the terms of this agreement. And we've also got, I've highlighted there, any instalment of rent which is due but remains unpaid at the end of the tenancy. So what that means is, looking at those two clauses, is that the tenant was obligated to pay £900 rent every month. And if they don't pay that rent every month, then the agent, with the consent of the landlord, can deduct any instalment of rent which is due from the deposit. So that would be sufficient legal obligation and clauses there to enable a successful claim against the deposit. Now, just at the bottom there, it says, what if I'd like to change my rent payment date? So as it currently stands, it is possible to change your rent payment date, and perhaps your tenancy starts mid-month and you want to pay at the start of the month. So sometimes agents permit tenants to pay a bit of extra money so that they can move their rent payment date. However, with the Renters' Rights Bill, that might actually change and that might no longer be permitted. But as it stands, providing it's agreed between the parties, then that it is possible to do that. So we've got some more clauses here. We've got the term of the tenancy. So the landlord lets to the tenant the property for a period of 12 months. The tenancy shall start on and include 12th of December and shall end on 11th of December the following year. Now, this is an important clause to understand because it sets out the term of the tenancy. And if you're signing a tenancy agreement, you are agreeing to take on that property for that entire term. You're agreeing in a contract, a written contract, that the tenancy will last for that fixed term period of time and that you will pay rent for that entire fixed period of time. Now, sometimes perhaps circumstances change and tenants ask to leave early. And we've got an early termination clause here where it says if the tenant vacates the property during the term, apart from according to an agreed break clause, the tenant will remain liable for rent, council tax, utilities, and any other monies payable under this agreement until the term expires. So it's important to understand, just because you want to break the agreement, it doesn't mean that you necessarily can. You would need to get agreement from the landlord, because you would be liable for all rent and bills for the duration of that fixed term. Now, it might be that a landlord agrees to release you early from the contract, which you can do if you both agree to do that. But there are often costs involved with doing that. And you should just certainly be aware of that. And if you do agree to break a tenancy earlier, make sure that you're very clear and understand the costs involved. So the burden of proof is an adjudication principle, and ultimately the burden of proof when it comes to adjudication about tenancy deposit disputes, the burden of proof lies with the landlord. So what that means is it's the landlord's responsibility to show that they're entitled to claim from the deposit. And the reason for this is because it's the tenant's deposit. The tenant paid the deposit, therefore it belongs to them. And if the landlord doesn't satisfy that burden of proof, so they don't have any evidence perhaps to support the claim that they're making against that deposit, then that deposit must be returned back to the tenant. However, the burden of proof does shift backwards and forwards between the parties. So perhaps a landlord provides really good evidence to show that they're entitled to claim from the deposit, but perhaps the tenant has a counter argument to that evidence. They might say, oh yes, but we reached an alternative agreement elsewhere, and which changed the terms of the tenancy agreement. At that point, the burden of proof would actually shift back to the tenant to show that what they're saying is the case. So the landlord's done their job. They've got their check-in report, check-out report, tenancy agreement. The tenant's saying, no, but we had another agreement. So the burden of proof would then shift to them to show that that was the case. So it does shift between the parties, but ultimately it lies with the landlord. TDS adjudicators, we work on the balance of probabilities. If you went to court, it would be beyond reasonable doubt. But we actually work on the balance of probabilities. And what that means is what's the most reasonable outcome to this dispute? And really an adjudicator only has to be persuaded 51% in favour of one party in order to make a decision. A TDS adjudicator will take documents at face value, so we will accept those documents as they're presented to us and consider them at face value. We do sometimes get allegations that documents have been fraudulently altered, but that's actually a criminal allegation, and it's outside of the remit of TDS. And it's really always a good question to ask yourself, really, is the claim fair and reasonable? So that's what an adjudicator will do as well. They will question, is that claim fair and reasonable? So talking more detail now about claims for rent arrears specifically. So what period is being claimed for? That's a question that an adjudicator will need to know, and that's what they'll be asking of the agent landlord. You know, have they clearly set out their claim? What period is this rent arrears supposedly have happened? How have the arrears or interest been calculated? You know, an adjudicator will check that those arrears have been calculated correctly, and certainly that the interest has been calculated correctly. We do see lots of weird and wonderful calculations sometimes, with hundreds and hundreds of pounds worth of interest, and often when we've calculated it correctly, it amounts to just a few pounds there. We'd like to see rent statements and bank statements showing evidence of payments that have gone in. Usually agents and landlords will provide rent statements, and tenants will provide bank statements to prove that they've paid some rent. Perhaps a month's rent has gone missing somewhere. But ultimately, who is responsible for proving the rent is paid? Ultimately, that responsibility is the tenants. It's the tenants who are responsible for showing that the rent is paid. So it is important that you keep records of those bank statements. And if needs be, contact your bank, and they can actually do a search to show that that payment has actually reached the agent. So not just been sent. Oh, apologies. I think can you still hear me, Sam?
Yeah, we can all hear you fine.
Oh,
you just went back for a second, but all good.
Yeah, sorry about that. So it's the tenant's responsibility to prove that the rent has actually been paid, and banks, if you contact them, they can actually provide you with evidence that that amount has been received by the landlord or agent. Now, if a tenant actually agrees for the deposit to be paid towards any rent arrears, then there is no dispute for TDS's purposes. It might be that a landlord or agent would like to claim damage or something else, and they might say that we want to claim that from the deposit and perhaps pursue a tenant through the courts for rent. But if a tenant actually agrees for their deposit to be paid towards rent, remember it's the tenant's money, and it's for them to choose what it's paid for, then it must go towards the rent, and actually there would be no dispute over the deposit there. Now, when looking at rent statements, an adjudicator will expect to see the relevant property in the tenancy period, the names of the tenants, the rent due, the due date, the period to which the payment relates, and the rent paid and the balance of accounts. So an adjudicator will want to see all the rent payments made by the tenant throughout the duration of the tenancy, particularly if payments have been made sporadically or in part at some stages, just so that they can fully calculate if any rent is actually due. Now, I've just got a little case study here to run through with you. So the landlord here in this case was claiming £77,000 in rent arrears. So a large sum of money here, as they said that the tenant stopped paying rent due to an ongoing leak in the property. The landlord said that the damage from the leak was limited to the entrance hall, was minimal to begin with, worsening over time, but that no parts of the property became uninhabitable at any time. The tenant disputed that rent arrears were owed, as they believed that the property was uninhabitable due to the ongoing leak during the tenancy. A copy of the tenancy agreement was provided. The total deposit was £9,000, and evidence was provided to show there was an issue with an ongoing leak in the property during the tenancy. Rent statements were provided to show that the tenant had not paid the rent during this period. Now, to break that down, we do have a copy of the tenancy agreement, which would have an obligation for the tenant to pay rent, and a deposit use clause, which would set out a permitted purpose for the rent to be used. We've also got a rent statement there from the landlord, which shows that the tenant hadn't paid rent during that tenancy period. So the burden of proof lies with the landlord first. They've given us their evidence, and actually they've supported their claim very well here. Now, the tenant's disputing that on the basis that they think the property was uninhabitable. So the burden of proof is shift back to the tenant here to prove actually that the property was uninhabitable. Now, It's quite rare to see a case at TDS where a property was deemed to be so unlivable that rent was not payable. But certainly what a tenant should be doing in this instance is getting some evidence that it was uninhabitable. Just because a tenant says that the property is uninhabitable, or they feel that it's uninhabitable, doesn't necessarily mean that it technically is. And really, what the tenant should do in this instance is, contact their local authority, who will do an inspection of the property, and they are qualified to be able to determine if a property is in fact uninhabitable. So, without that evidence, just having a leak in a property doesn't necessarily mean that it's uninhabitable and that rent isn't due as a result. And also remember that TDS doesn't consider counterclaims. So this seems to be a big counterclaim from the tenant here, perhaps justified, perhaps not. However, it's outside of TDS's remit to consider that. So in this instance, the landlord had supported their evidence, supported their claim for rent arrears sufficiently with objective evidence, and the claim was justified.
So we've just got this slide here, just examples of if that scenario there is something that piques your interest, or you sort of want some, different sort of examples. On our TDS website, we do have a whole variety of different sort of case studies. Anything that, one, has either been an interesting case, or two, things that we just see quite frequently. So what I would recommend, if it is something that you are interested in having a look further, is to go to our TDS website. And quite well that if you do just sometimes put in TDS case studies, it will just populate this this actual web page here. If that is something that you are further interested in, please have a look up there. There is, as I said, a whole different variety, sort of different case studies, and we keep them constantly updating. So they're not just they're not just one sitting there. So if anything new comes up, we will update it and put them on there. But sometimes it's useful just to have a browse, especially if you are perhaps either coming to a dispute with a landlord, or it's something that you are currently in dispute with. You might be thinking, what sort of evidence may I need? Or, if there was a case that went to TDS in a similar nature, maybe you can sort of give it a look and sort of say, look, the adjudicator in that scenario went this way for these reasons. So maybe I can find this piece of evidence to counter that. Or perhaps you might think, actually, my claim is going to be successful, so to make sure that I provide the relevant and correct information. And just to touch on T-Life. So we haven't mentioned it as of yet, but essentially what it is it's an app that you can download onto your phone, and what it does, it's set up for tenants, and it's essentially there to do a lot of the sort of how could I say it, but the sort of the background that you may need if you're essentially trying to take on a tenancy. So what it does, it puts a lot of the control to the tenant themselves. So if you were to, you're trying to find a property to rent, and you want to put your best foot forward, what it allows you to do is it allows you to essentially pre-qualify, and I put those in quotations there, but it allows you to pre-qualify all the things that you may need. So you can sort out all your references, you can verify your ID, and you can do that all through the app. And the reason why that might be helpful is if in a scenario where you are trying to take on a tenancy, if you've already got that all up and running, essentially, you've put your best foot forward. You're perhaps maybe one step further than another party, and essentially can help you to get that tenancy. So what it does do, and I think it may be the next slide there, is, as I said, is very easy to use and very sort of user friendly. But how it works is once you fill in all the sections that you need to do, it essentially gives you a QR code, I believe, and that QR code is then shown to either the agent or the landlord, and once they scan that QR code, all your information is relatively there and available. So we sometimes just put that in near the end of the session, just in case it's something that you might be of use to you, or something that you think might be helpful with the future. Please just take that away. But it's T-Life, and I've just that back there if you need to see how that's spelled. A bit of a rogue spelling there with the word life. So that is that's us coming up to the end of just the standard presentation. I'm conscious of time, but we haven't had any don't seem to have any questions come up in our chat as of yet. So if you have got any questions, please just pop them in the chat there. As I said, on the left hand side there, we'll be happy to answer. It could be anything that you've either heard in today's session, or just something that maybe we didn't touch on that you think actually it might be useful to use our expertise and knowledge to get that answer to you. So I'll just wait a couple of moments just to see if anyone's typing and popping anything in that chat.
I've got a couple of frequently asked questions, Sam, that just to give people a moment to think of any questions. So what happens if the landlord wants to claim more than the deposit amount for rent arrears?
So yes, so we've it's, you know, as can appreciate that. I'm just thinking back to that case study there that we just showed of 77,000. It's going to be very unlikely that you are going to get potentially a deposit that gets to that amount. So if there is ever a scenario where perhaps a landlord is claiming for more than the deposit amount, it's very important to remember tenancy deposit scheme, TDS. You know, we could only ever award the amount of the deposit. So if it's potentially something that, you know, a landlord's trying to claim more, and from a tenant perspective, you know, you're worried that, you know, my deposit's £2,000, £3,000, it's being £4,000 claimed here. The maximum that TDS would be able to award is the deposit amount. So in that scenario, obviously if both parties have consented to it, it would be on the understanding of that it is going to be capped at the deposit amount. Doesn't seem like we've had any questions come in the meantime. I will just, as I said, I'm conscious of time there. I know everyone is busy there, but in case anyone does, we're still happy to answer. But in case we don't have any questions, I'll just I can just wrap up at the end there. But thank you everyone for joining us on today's session. I hope it was useful to you. I hope it was. I provided some knowledge and some further sort of guidance on the sort of things that may help in a tenancy. Also, thank you to Louise there for going over a lot of those slides and the case studies. And yeah, as I said, thank you everyone for joining us. But it doesn't seem like we've had any questions. So either that means we've answered everything really, really well, or everyone's got so many questions they can't type away there. But we have put our email addresses at the start there. So if you haven't jotted them down, what I will do is I will just pop in my email address onto the questions tab there. So if any questions do come up, please don't hesitate to just send me an email and we'll get that answer out to you. But if that is all, and I am just leaving it the last few seconds to see if we have anything come in, but I will just say thank you everyone and enjoy the rest of your afternoon.